May it please the court?
Yes, sir, you may proceed.
Thank you. My name is Adam Richardson, and I represent the plaintiff appellant. I'd like to reserve 5 minutes for rebuttal.
Very good, Mr. Richardson.
Of course, we're asking the court to reverse a summary judgment. The first thing I want to talk about is something I had noticed in the record in preparation for oral argument that I had missed in preparation of the briefs. It's in the record, though. It was properly supplied to the trial court. In fact, the trial court invited the filing of it after the hearing because it was something that had been brought up. And that is photographs of the condition, the board, on the day of the accident. What happened was the plaintiff's daughter came over after the plaintiff fell and took 3 photographs of the accident. So this is something that the trial court necessarily considered after the hearing because he invited it, they were filed. The other side didn't object to those particular photographs, only to other photographs that had been filed. The record citation, I think, for the best photograph was page 588. The picture clearly shows a decayed board. It's very clearly split. It looks like there's part of it that might be rotten. And the split is very clear. It's down the middle of the board, and there is quite a gap between the 2 sides of the split. So in this case, we have not just the testimonial evidence, but photographic evidence.
Because I think you have a bit of a, in looking at all the facts here, you do you know what you have to show.
Yes.
You have to show that somehow Ms. Trumble should have known or was on constructive notice of this condition, and that condition was there for some time. And the judge below, as you know, wrote in his order saying that you are impermissibly stacking inference upon inference, which based on the case law is really not appropriate. So the first question that you're based on this facts, even with the photographs, even with everything, what the judge below said, you're speculating. We're speculating that this has been there for a while, considering the facts that 8 months she lived next door, and for 8 months she resided in the place. She went up and down those steps 32 or 30 plus times. How do you get around all that, Mr. Richardson?
Yes. Again, yes, of course, this case involves a more limited duty than in the typical premises liability case. It's whether the defect existed at the time of the transfer.
And of course, there was an inspection done prior to transfer with a handyman, and then also with your client walked the same premises before she took possession of the tenancy of the property, correct?
Yes, sir.
So there were 2 inspections, 32 trips across the same area. Enlighten us.
That property that she lived next door to before she rented it. So she had really a unique knowledge of this property.
Yes, Your Honor, and I think as we stated in the briefs that goes more to comparative negligence. I think the court in Markell versus Mikasa, which is a 4th district case, made that very clear.
But isn't the landlord's duty, they have a duty to inspect and a duty to make repairs if there is a dangerous condition or some condition that comes to their attention? And didn't they do that here? I mean, didn't they fulfill what their duty is?
No, Your Honor. The ultimate question here...
I think in your briefing you're taking the position that they needed to somehow get underneath the deck and look and inspect the underneath of it, even though nobody had noticed any issues with the weakness or cracking, potential for cracking or anything. That's where you're going with this.
Yes, Judge, but I don't think that's the issue that's on appeal. I think the issue on appeal is a different one, whether there would have been constructive notice had that reasonable inspection occurred. I think the reasonable inspection is a separate issue that would be resolved on remand if this court were to reverse.
Well, there was nothing in front of the court at the time of the summary judgment on that point. I believe there was an attempt to bring an affidavit into the proceedings sometime after the judgment had already been entered.
Yes, sir. There were 2 affidavits, an original and amended, but I'm not relying on that because I think there were procedural issues there.
Okay.
But the motion was based not on whether the inspection itself was reasonable, but on whether they had constructive notice. I think the case law is pretty clear that a summary judgment can't be granted on an issue that wasn't in the motion. I think that implicates due process rights, and it would be inappropriate, even I think, to affirm on tipsy coachman grounds, because that was not what was the issue raised in the motion. I just want to talk a little bit about the permitting of inferences rule. I think the court's probably noticed that in the past several years, it's been harshly applied. It's moved on from something that was supposed to be not a categorical exclusion of the use of inferences to something that's much stricter. In the seminal case one of the two seminal cases, Volcker, the Supreme Court described what a reasonable inference is, and the court said that it accords with logic and reason or human experience. That is not the high bar, I think, that many courts and lawyers believe it to be in establishing that the original basic inference.
But we would have to infer that 8 months after the fact, that there was this defect in the deck, and that had somebody gotten down and looked underneath, that they would have determined that and something would have been done about it.
Yes, sir, that is our argument and our theory of the case. And I guess
one thing that hasn't come up either is this incident wasn't reported until 8 months after it happened, isn't that right?
Yes, sir. In the plaintiff's deposition, though, she offered an explanation, and of course the credibility cannot be questioned for the purposes of summary judgment. She said that the injury that she had sustained was extremely serious, and that she was very emotionally upset for quite a bit of time after that. In fact, that every time she thought about it, it made her cry. And that's why there was a gap in time between the date of the accident and when she told her landlord.
Okay, but I mean, it would seem that sometime in that 8 months there'd be an opportunity to make a phone call and just say, hey, this deck is defective, let's go look at it right away. It just seems peculiar that it took that long, and understanding that she's upset about it.
Yes, sir, and I think that is a credibility determination that a jury would have to resolve. I think that very clearly would turn on the plaintiff's credibility.
So the bigger concern I have is it really appears on the facts that we have here that the tenant had the superior knowledge of the property, even over that of the landlord, because the landlord never occupied this property. The landlord bought this property simply as a rental property, hadn't owned it all that long. The tenant lived next door for several years to this property, and then when it became vacant, decided she wanted to rent the property, lived there for the period of time that Judge Black has just walked you through. So frankly, if anybody knew about that deck, it's going to be the tenant's going to know far more about it than the landlord did, who never lived there, but only have it inspected between tenancies. So it's really, if there was any concern about the deck, quite honestly, I think it's the tenant who should have crawled under and looked at it.
Yes, sir, but I think if that were true, that would be true in almost all of the cases involving transfers of property to residents.
I don't think that is true. These are unique facts. How often do you have a tenant living next door for years who decides to rent the house next door because they've observed it over the years, decided they liked it for whatever reason, and then lived there for a period of time, transversing this deck for a period of time? I would hazard a guess, based on the facts we have, that tenant had been on that deck far more times than the landlord had been on that deck.
Yes, sir, but again, I think that goes to comparative negligence and possibly open and obvious condition. And the case law, Markel, says very clearly that that's what those issues relate to, those factual issues. I think that, again, even if on these facts that conclusion could be reached, and I think a jury may be able to say that would totally discharge the duty that a landlord has to the extent where, as a matter of law, this duty simply would not exist in the case. The duty is established under Mansur. The landlord has the duty to reasonably inspect the property before the transfer to the tenant. I think following the court's reasoning, or the implicit conclusion, is that under these facts, the landlord simply had no duty at all. The proximity of the landlord to the property, I think, is not a relevant.
It's not that the landlord didn't have a duty. This is the exact opposite of an open and obvious. There's absolutely nothing for years indicating any issue with this deck, before, during, and for 8 months after. I mean, there's nothing here. Nobody said to the landlord, look, the deck's decaying, there's a problem, the boards are rickety, the nails are coming out. There's nothing. And she'd been walking across it 32-plus times and no problems at all.
Yes, sir.
That's expecting an awful lot. I don't think the law demands that of a landlord.
Yes, sir. But again, I think that that is a separate issue, whether what a reasonable inspection would have been. Would the reasonable inspection have just been looking at the surface of the deck, or would it have been under the deck? And I think that's a separate issue, but the deck was elevated. This was probably an older
And
Florida
had they
home.
looked under, would they have seen anything, given that it didn't fail for months after she took possession?
Well, I think, sir, if you look at the picture of the deck, in fact, the specific board that she tripped on 588, that creates factual issues because of the extent of the decay on the board.
And I think that's where the concern is. You're asking the assumption based on a photograph without any evidence presented by experts saying that condition existed. It's been there for a year. It's been there for a long time. You have no evidence of that. You're just taking a photograph, you're showing it to the court, and you say, oh, look, you have to assume that, first of all, it's rotted based on the picture. Then you have to make the further assumption that that rotten wood was in existence several months before. And that's where you have the improper stacking of the inference. And that's why the court concluded appropriately that you cannot have an improper stacking of the inference. And so just by your words right now, say, look at the photograph, well, you're making an assumption. We can't do that.
Yes, Your Honor, but again, there is an exception to the rule, and it's if the original basic inference is established to the exclusion of any reasonable other inference, that it can be deemed an established fact.
And I think that's where, regretfully, it fails here, because there's nothing that's been presented to the court. It would have been great to have an expert say, I've inspected this property, and based on my expertise, I could let you know that this was, in fact, because of my conclusion that no other reasonable way that this was in existence way back when, I grant you that. That would have been enough to get you in. Then all these others as comparative could come through. But that's even deficient. And you have to look at the record, the facts that are presented, and that's where it's woefully deficient under this record.
Yes, Your Honor. I don't think expert testimony would have been necessary. I think the condition of wood and how it ages is a matter of common knowledge.
And I think that's where we disagree.
Okay.
Because none of us are experts in woodworking. And one piece of wood could be different from another piece of wood. Certain wood could, even with rain and whatever, could withstand. African wood is amazing. That other kind of wood could be horrendous. And we're not in the business saying, okay, what kind of wood is this? What would be reasonable? We can't do that. And that's what you're asking us to engage in by making reference to a photograph. And respectfully, we cannot do that.
I understand, Your Honor. If the court has any questions, I think I'll take the remainder of my time for rebuttal.
Very good. Thank you, sir.
Thank you.
May it please the court, my name is Ezekiel Lugo, and I represent the appellee, Linda Trumble. This court should affirm the summary judgment because there was no evidence that this condition existed at the inception of the tenancy, which is a key fact under the duty imposed by the Mansour case.
What about the expert affidavit that came in after the judgment was entered? What do we do about that?
Well, there were two affidavits, Judge Black. The first affidavit that came in, it merely said, it was titled Sworn Written Statement, and it's on page 614, 615, and it does not state that the condition existed at the inception of the tenancy. Okay, they fixed that in the subsequent affidavit.
The one I'm referring to is the amended one that came a month or so, or maybe a few, I think maybe 10 days after the judgment was entered, the amended affidavit came in.
It came in as part of the motion
Part of the rehearing.
for rehearing.
What do we do about that?
Well, that issue has been abandoned by the plaintiff.
By not being raised in the...
Well, not only was it not raised in the initial brief, But the answer brief specifically said, look, they didn't raise it in the initial brief, it should not be considered. At that point, they had an option of moving to amend the initial brief to raise it if in fact that's what they wanted to do. That didn't happen. And in the reply brief, they basically abandoned the issue completely. And I think I heard during my opponent's presentation that he's not relying on the affidavits because they had problems. And some of the problems, technical problems with the affidavits, the main one is that by the time the summary judgment had taken place, the expert disclosure deadline had already passed, and this particular person had not been disclosed as an expert. So the defendant, in response to the rehearing, and in fact in response to the first affidavit, had raised the issue that this person had not been timely disclosed. So technically there are issues with compliance with the trial court's disclosure deadlines, and on appeal there are issues with the consideration of the affidavits because it's been abandoned by not being raised in the initial brief and affirmatively being abandoned in the reply and here today before the court. I want to address the issue with the photograph. It wasn't raised in the initial brief. There is a case cited in the answer brief, City of Miami versus Navarro, which also involved a photograph, and it was a photograph of a raised brick. And the Third District Court of Appeals said exactly what Judge Kuzam was describing today, which is the court can't infer from the photograph alone that the condition shown in the photograph in fact existed or predated the date of the accident. Something else is required, either testimony as to how long it would take for that condition to develop, which is not present in the record in this case, or some kind of expert testimony that would place the condition in existence at the time, in this case, that the tenancy was turned over. And neither one of those are present in this case, so legally the argument should be rejected under the City of Miami versus Navarro case. As the court has noted, this deck was inspected. It was inspected by 3 different people. The landlord inspected it. She saw nothing wrong with it. The tenant went out to the back and looked at the deck before she signed the lease. She did provide a punch out or a list of issues that needed to be corrected. There was nothing about the deck on that list. There were issues with the bathroom, and I believe there were some issues with the flooring inside the house, and those were taken care of. The deck was also inspected by the handyman. He looked at it. He said it was solid. It was weathered, but it was sound. It was solid. There were no issues with it. It was pressure washed at that point. And then she was in possession of the property for 8 months, using this deck once a week, at least 32 times, and she never saw any issue with the deck. She didn't report anything to the landlord. So these facts refute the inference that opposing counsel is trying to have the court consider. These facts make the inference unreasonable. It's unreasonable to interpret the evidence to mean that the 32 times she walked through the property, this condition existed there, and she never once saw it and never once reported it to the landlord. It's also unreasonable to think that 3 different people looked at this deck and didn't see this condition at the inception of the tenancy. So for these reasons, that inference itself it's unreasonable, separate and apart from whether there's any stacking of inferences at issue in this case. And that was the basis of the trial court's ruling, that there was improper stacking of inferences, and as Judge Kuzam noted earlier, there are multiple layers being stacked here, that the cracking was because it was rotted, that the rotting was there long before the accident, that the rotting and the cracking were there, in fact, on the date of the inception of the tenancy. For that reason, the summary judgment was appropriate in this case. And I also want to address this Markel case that opposing counsel keeps mentioning. That case is distinguishable not just because it was an open and obvious case, but because in the Markel case, there was an expert affidavit that said that an inspection, that the condition would have been discovered, quote, during the normal course of inspection at any time after the initial installation of the plate and weather stripping. So that affidavit made it clear on the record that an inspection at the inception of the tenancy would have revealed the condition. That evidence is completely absent in this case, so the Markel case is distinguishable for that second reason. Unless the court has any further questions,
No, sir.
we respectfully request that the court affirm the judgment in this case.
Thank
Thank
you,
you.
Mr. Lugo. And Mr. Richardson, you do have your 5 minutes for rebuttal, sir.
Hopefully I won't take up that much
All
time.
right, sir.
I just have a couple of points. I think, Judge Black, that the motion for rehearing was a discretionary decision on the part of the trial judge. That's the reason that we didn't raise it, or that we're relying on the amended expert affidavit. And I think, again, I agree with opposing counsel.
Good for you
Thank you, sir.
for conceding that point.
Yes, as to the original affidavit, I think there were the procedural problems that the expert deadlines had closed. I don't think it would be proper for us to rely on the original affidavit either. So we're relying solely on the fact witness testimony and the photographs that are in the record.
Okay.
The inferences, they're trying to stretch out one inference into multiple inferences here. And that's actually something that the 4th District in the O'Malley case noted. That case actually involved only one inference, but I think it applies as well when you're looking at what the inferences to be drawn actually are and the potential for mischief in the rule against the pyramiding of inferences. Here there are only the two inferences. One, did this condition exist at the time of the transfer of the property? Two, would a reasonable inspection have, really, whether or not the landlord would have had constructive notice or knowledge of the defect in the deck. I don't think there are three inferences, as opposing counsel has said in the answer brief, or multiple inferences that the opposing counsel is trying to offer. I think unless the court has any other questions, that was all I wanted to respond to in rebuttal.
Gotcha. Very good. Thank you,
Thank you.
Mr. Richardson. Thank you, Mr. Lugo.